Today we are going to be looking at who is telling the truth during fact-finding hearings and why, in my opinion, it is one big farcical game. But before I divulge all, let me run my excellent introduction. I am Philip Kedge, the director of the brilliant McKenzie Friend UK network, and in my amazing and fearless vlogs, nothing I say represents legal advice, because you don't need rip-off, all too often sick in the head family court lawyers in the family court, and where my opinions are entirely my own. So let's get down to business. If you are a father, the non-resident parent, currently with no contact and facing a fact-finding hearing, all I can say is that my heart goes out to you. Life is certainly not looking great. And the chances are that whilst you think you are fighting for truth, justice and fairness, the reality is that the playbook of hate is being used against you, and you are about to be thrown under the family court bus. So what do we know? Well, we know that in about 80% of family court cases there are allegations of domestic abuse. Of course there is. What do you expect? There is a very fine line between love and hate, and hell has no fury like a woman scorned. And when I say woman, of course we can, thanks to the Supreme Court ruling, move forward safely in the knowledge that that is the one without a penis. Now, this is what I think from over a decade's worth of experience in our beloved family court. That out of all those allegations of abuse, only about 20% of them are what I would consider as being significant abuse, where there is a clear need to safeguard the children and the mother. So we are not going to be talking about those. The problem I have is the remaining 60% of cases where the allegations amount to nothing more than a total load of bollocks, thrown about by often vindictive, irrational, hateful, emotionally unhinged parents who are the mostly mummies. Mummies who are hell-bent on weaponising the family court and the children against the fathers to reduce, restrict, minimise, or even better, to deny child contact with the father. Now then, what happens at fact findings when you are the father faced with accusations based on nothing more than a total load of bollocks? Well, the judge, all too often from planet stupid, with absolutely no application of common sense, is going to determine facts. Now that word is important. They are determining facts, not the truth, based on balance of probability. You see, in the vast majority of cases where allegations are made, it is simply one person's word against the other, with no corroborating evidence. So we will never know the truth, but the judge will determine facts, and in that lies the problem. When an allegation of domestic abuse or coercive control is made against you, you can only respond in one of three ways. Firstly, that you admit it in full. Secondly, that you deny it in full, that the event never happened and that it is a total fabrication. Or thirdly, that an incident did occur, but the context presented to the court is false. Indeed, the father may often claim that they were the victim defending themselves. Now, the judge, when listening to both the parties' accounts, has to determine the following. If a party is telling the truth and the entire account is believable, whether the account given may partly be true but perhaps exaggerated, whether the account is false, or whether the person honestly believes that their account is true, meaning that although there may be discrepancies in it, they are not strictly lying. So, in the family court, you get a judge sitting on their own, no jury in sight, trying to work out all of that and then determining facts, once again, not the truth, but facts. Now, here's the rub. I argue that the deck is stacked entirely against the non-resident parent, who are the mostly fathers, and that deck is stacked against them in three ways, resulting in a likelihood that they will be thrown under the family court bus and labelled a domestic abuser and child abuser. Reason number 1. Judges are, in my opinion, naturally risk averse. Not a criticism, that is a very natural human trait of self-protection. If in doubt, call the father out as a domestic abuser, because that is the safest thing to do for the children. And why would a judge want to put their £120,000 a year pay packet and pension on the line if they get it wrong? And there is a catastrophic event that follows. Far easier to find facts against the father. Reason number 2. The family court doesn't want to further upset the already emotionally unhinged mummy because she is looking after the children. What is gained by calling the mummy a liar? She will only double down on resisting contact, making it virtually impossible to move forward. If you keep the mummy happy, then you keep the children happy. Far better to throw the father under the family court bus in the hope that it makes the mummy feel vindicated and open to moving forward. And thirdly, and don't get me on this one, there is case law on this that states that if the mummy is an alleged victim of domestic abuse and some of her evidence is contradictory, forgetful, or perhaps not entirely coherent, then the judge must consider that any lack of clarity or omissions in her evidence is down to the fact that she is a victim of domestic abuse, and hence giving evidence is very traumatic, reliving the past trauma, meaning that she is unlikely to be able to give coherent evidence. Blimey, talk about the father being screwed over even before the fact-finding begins. But of course, if the father states anything slightly contradictory in his evidence, then that must be because he is guilty, guilty, guilty. So from my extensive experience, I would suggest that in 90% of fact findings that I could write the final judgment for the judge before the case is even heard, cutting and pasting the paragraphs that state that the mummy's account was honest, reliable and believable, and that the father's account was, well, evasive, defensive, and that he came across as an unreliable witness. And hence, in order to appease a mummy, findings of domestic abuse and child abuse are far more likely than not to be made against the father. So going back to the beginning of this vlog, when I suggested that if you are a father facing a fact-finding, approaching it believing that you are flying the flag of truth, justice and common sense, then your battle is likely to be a lost cause from the start, because fact findings, in my opinion, are nothing to do with the truth, nothing to do with justice, and nothing to do with common sense. So perhaps the best approach is to mentally and emotionally prepare yourself for an outcome that you may very well not like, all in the aid of risk aversion, keeping the mummy happy, and where the deck of victimhood is stacked against you at every turn. That's me done, folks. Please let me know in the comments box below, am I right or am I wrong? If you are facing allegations of domestic abuse and coercive control, or indeed for all aspects of your family court case, contact me right now at contactphil.co.uk. And please don't forget to like and subscribe. Until next time, stay strong.